Samantha. Hi Martin, my question this evening is regarding financial evidencing. Can you expand and elaborate on examples of holding joint liabilities together? Whilst we want to have property purchase in future, we do not currently have any large joint liabilities, mortgage, car loans together. Can you delve into some smaller joint liabilities we maybe haven't considered? I suppose off the cuff, Samantha, off the top of my head, a small financial liability that you may consider, and I'm not sure necessarily if it's suitable, and obviously you have to consider this between you and your partner, is a small credit card. A credit card with a small limit is in some sense very similar to a small loan, and I have seen many couples use credit cards as part of their financial evidence, and specifically in relation to joint financial liability. So that's one example I can give you. If couples are cohabitating and they have joint leases, I know that may not necessarily be relevant to your case, Samantha, but couples that have joint leases are jointly liable for the payment of the rent. It's a contractual obligation. That's a joint liability, in addition to being evidence of cohabitation. So it kind of ticks two boxes there, or two birds with one stone, so to speak. So there's a couple of examples that I can give you right now off the top of my head, Samantha. Marushja. When applying for the 651 visa, should I say that I intend to stay temporarily, even though the plan is to apply for an 820 once I'm in Australia and stay permanently? So Marushja, firstly, whether or not 651s are being approved at the moment is unclear. There is, I suppose, reports of some 651s being granted. And I suppose this is kind of where the travel exemption tool fits in, that we might be able to start seeing some trends or examples of temporary visas that were held or applied for in combination with the travel exemption, so we can start to see what visas are being approved. But there's an unofficial position that the department have not paused 651s, but they've slowed them down, and only very few are being approved. From what we understand, they're trying to funnel everyone into applying for the subclass 600, which is, let's say, a manual visitor visa. It's assessed manually, versus the 651 or the ETAs, which can be instantly approved under normal pre-COVID circumstances. In terms of whether or not you should declare your intention to apply onshore, I've said before that there is what's called government policy that allows case officers to approve visitor visas, including 651s, even if there's a declared intention to apply for an onshore partner visa. The reason is that with 651s or ETAs or 600 visitor visas, the key criteria is that you intend to stay temporarily, that you meet the genuine temporary entrant requirement. So I suppose most commonly what people provide, or what they say when they apply for these visas, to satisfy that requirement, they say that they're going to go back home. They provide, return flights, they provide evidence of employment and property ownership, and that their family's overseas, and they specify that they're only going to stay for that short period of time on the visa, and then they're going to go back home. That's how I suppose you would apply traditionally. However, like I said, there is room there for department case officers to approve these types of temporary visitor visas, even if there's an intention to apply for an onshore partner visa, a declared intention. Because the way the government approach that scenario is that they say it's not about the applicant of that visitor visa or 651 being able to prove that they're going to go back home necessarily. It's about the applicant proving that they're not going to overstay the visitor visa, that they're not going to breach their no work conditions of the visitor visa. And there's policy there to allow those visas to be approved. If there's supporting statements from the Australian partner, the Australian sponsor, that says, I'm going to make sure that they don't overstay because we're going to apply for an onshore partner visa, that will lead to a bridging visa, so therefore they never become unlawful. And secondly, they're not going to work because I'm going to financially support them during the period that they are here on their visitor visa, and then once they're on their bridging visa for the partner visa, they have full work rights. So there is room there to be open about your intention to apply. So Marusha, I can't advise you specifically whether you should or shouldn't. I suppose I just wanted to open your eyes to that possibility. You're more than welcome to get in contact with our office if you want to have a conversation about that formally. I do have to say that with COVID, there are obviously complications around obtaining permission to travel and visitor visas to Australia, but it's not impossible. So there's a lot of things to consider. But my answer is that you can still declare your intention to apply for a partner visa and still get those types of visas approved. Whether you should or shouldn't is a conversation we'd have to have formally though. Monse. Hi Man, there are some travel exceptions Facebook groups, communities that I've seen quite large. I believe that it would be good to ask people in these to use your tool for further data collection. Monse, absolutely. I suppose I can't go into those groups and post the link because I don't want it to seem as spam. I don't want it to see it. I don't want the administrators of those Facebook groups to perceive that we're using the tool to try to pinch their members or to try to encourage members to engage with us necessarily. I mean, obviously there is an indirect benefit for us, for people to use the tool, but that's not why it was built necessarily. So with all that being said, anyone who's watching this stream is more than welcome to share that link, share that post, and and then people are welcome to use the tool. It's open to anyone who wants to use it. So if you are part of a community that there's people in similar scenarios that also need that type of information, by all means, you're most welcome to share the post and link. I think it would be better coming from you guys than from me. Samantha. Hey man, my partner and I were wanting to strengthen our financial aspects, joint Australian bank accounts back in May. Unfortunately, due to COVID-19, it's been abbreviated. COVID-19, that's a lot easier. We haven't been able to strengthen our onshore financial situation due to travel restrictions. Is there any recommendations that can build on the Australian financial aspects side during this time with COVID-19 conditions in mind and the applicant being offshore? Samantha, I think we've kind of touched on this in other Q&A streams and during the live training, but I understand it's kind of a pressing point and it's relevant to a lot of people, of course, being physically separated. So happy to go over it again. I feel that there's really a handful of things that you could do. And guys, I just noticed that my presentation slide has somehow disappeared. My apologies, but I'm still here, just the slide's gone. I suppose some things that you can do is show financial support of each other, so transferring funds to one another, whether that's using Western Union or other fund transfer agencies and companies. You can also consider bank transfers to one another. If you have the option to open up a joint account in either country, whether that's here or overseas, doing that and then potentially transferring funds from your individual account to the joint account, depending on who has opened the joint account. I mean, really those are, in terms of the realistic practical limitations that couples that are physically separated with COVID, trying to strengthen financial aspects, that's really all you can do. You can't really do too much because you're not physically together, which limits your ability to spend money together. But it's not about spending money. It's about trying to financially support each other in whichever way you can. So those would be my suggestions to try to strengthen that aspect. I would just kind of reiterate, and I know a lot of you who have attended our live training know this already, but I'll say it again. It's about trying to strengthen each aspect as much as you can, but just remember that all four aspects will be assessed collectively if we're talking about the offshore 309 or the 820. And for those applying for the prospective marriage visa, I suppose you would just kind of tone down the importance of the four aspects a little bit. It's not so much about the four aspects, it's more about your intention to marry and that you will live together as spouse and you've met in person. But even prospective marriage visa couples or those applying for PMVs should still follow that advice. Try to show fund transfers to one another to some degree. Particularly if it's, let's say, from the applicant overseas, transferring funds to the Australian, so that the Australian can then purchase items that will then be used by the applicant. Let's say, for example, furniture for their property that they will live together in once the applicant gets permission to enter or once the applicant's on shore. That can be used. Or if you're planning a wedding, using the funds to pay for the expenses of planning that event that's relevant to the relationship. I'm not saying you need to start planning weddings if you're overseas or physically separated. I'm just giving you some examples off the top of my head. I'm not going to try and pronounce that name. I will just read the question. Hello man, I'm currently in Australia with my girlfriend on a bridging visa and I have to live in a month to go back to Greece. What the solution you can suggest so the Australian government can let me back in case there are still travel restrictions? I suppose I would be curious to know why you are on a bridging visa. I assume that you've applied for another visa and that's still pending, perhaps another visitor visa potentially, or one of the, I suppose, COVID specific extension visas that just aren't being approved. They kind of just applied for and you just get bridging visas. So I assume it's going to be one of those. In terms of suggestions on what you can do if you do need to leave, I suppose, look, the first suggestion is there is the option of applying for the partner visa onshore, depending on your facts, depending on a lot of factors, but that is just one possible option. Applying onshore for the partner visa keeps you onshore waiting for that partner visa. However, that being said, because you have a bridging visa and you're trying to apply for an onshore partner visa, there's going to be additional criteria. It's called Schedule 3 criteria, which in simple language makes it very difficult to get the partner visa approved. So it's not always advisable. In my humble opinion, unless there's a pregnancy or a child of the relationship, it's a very high risk approach to try to apply for a partner visa and try to satisfy Schedule 3, or a Schedule 3 waiver is really what it's called. So, I mean, again, I would have to know more about the facts of the relationship. Putting that aside, assuming you do not apply for an onshore partner visa and you do need to leave, what you can do to try to come back, I suppose that answer is best given by looking at the responses to the travel exemption experience tool and what other couples have provided as part of their application. So one of the questions in that tool is, what documentation did you provide? And we give users the option to kind of tick, I suppose, the most common pieces of evidence that would typically be provided for a partner visa. So it'd be interesting to see which documents may lead to an approval, or, as in couples that were approved, what documents did they provide, and then try to provide the same things that they provided. I mean, that's how you maximize the likelihood of an approval. You base what you do on previous approved cases, right? That's just logical, and that applies to anything, not just partner visa applications. So that would be my answer, is have a look at the travel exemption form, keep an eye on the submissions, on the database, and try to mirror your application and your supporting documentation to approved cases. Okay, that would be my answer. Julia, hello man, my question regarding the living together part. Since my partner and I have only been together for 1.5 years, but the problem is we don't have enough proof of living together because my partner is the one who paid the bills and everything. Is it still possible to apply? Okay, Julia, so the first thing that I want you to do in answering this question is go to YouTube and type in Partner Visa Secrets 12-month rule. Okay, and have a look at my video talking about what the 12-month rule means when looking to apply for an onshore partner visa. So I assume you're looking to apply for an onshore partner visa, which means you're applying for the 820-801. And if you're not married, if you're in a de facto relationship, you need to satisfy the 12-month rule. So the length of time that couples live together is relevant to the 12-month rule. What matters most though is what's happening at the time of application. So how long have you lived together before applying? How long have you pooled your finances for before applying? And what did you do in your relationship timeline before applying? Time of application is key. Julia, I can't answer the question, do you have enough to apply for a partner visa based solely on the amount of time that you've been living together? That doesn't tell me enough to really be able to try to give you, I suppose, an informed opinion. However, to me, that's a good start. Having lived together for 1.5 years or 1.5 years is a good start. that to me probably suggests that you've been together for longer than that. So if you've been living together for 1.5 years, it tells me you probably met maybe 6 months before that or more. So if you and your partner get enough supporting documentation in place and strengthen your facts enough before applying, you're probably going to be in a good position to apply. However, I can't give you a definitive opinion without knowing more about your facts. Julia, my honest best advice to understand what really is required to meet partner visa criteria is just keep an eye out to see what our announcements are about our partner visa secrets training. So every month, we've hosted live training. You heard me talk about that earlier in the stream. We haven't scheduled the next intake. Like I said, we may be changing it to more of a on-demand, always available training. That decision is going to be made soon, probably in the next couple of weeks or week. So as soon as I know, I'll be posting announcements. Whether we do the live or whether we make it available to watch at any time, please watch the training. Just please attend the training and watch the training. I promise you, you will understand more about what's required. And that will give you the complete answer to your question. You'll have a much more comprehensive set of knowledge that you'll be able to answer the question yourself. Grace. Hi man, if we don't have a joint lease, would providing things such bank statement, a confirmation email from IMI that says change of residential plus postal address has been submitted, a confirmation email from electoral roll that says change of address plus postal address has been submitted, aside from letter utility bills, how much weight does item 1, 2, and 3 hold? So I suppose, Grace, there isn't any legal requirement that couples have joint leases. Okay, so let me just clarify that. It's not about showing you have joint leases. It's about showing that you cohabitate and that you maintain a household together as a de facto couple or as a married couple. Do you live together like a de facto married couple would? Having a joint lease is useful because it has both your names on it. It's a legally binding document. It's also a financial obligation / joint liability, which I mentioned to Samantha before. It's issued by a third party. It's definitive. It shows that you're cohabitating. However, a joint lease doesn't show you're cohabitating like a de facto couple. So just having a joint lease doesn't mean that you're going to tick that box. So just let me be clear, okay? So for couples that don't have joint leases, it's about trying to provide other documentation that shows you are living together. So depending on what your living arrangements are, you can provide, if you live with other people, supporting statements from your other housemates. If you live with family, supporting statements from family that attest that you live there. If you pay board, or if you pay rent, but maybe not for a joint lease necessarily, making sure you use a joint account to pay for the board, to pay for the rent. Other things like bank statements that are addressed to that address are good. You've mentioned 1, 2, and 3. I think they're good pieces of alternative evidence to a joint lease. To me, I think if you have those items plus the other things I mentioned, if they're relevant to your scenario, plus using the joint account to pay for the rent or the board, whatever the scenario may be, I think that's typically sufficient. So I think that they hold collectively a good amount of weight. But again, it will depend on all of your other facts, all of your other evidence for the other remaining 3 aspects. Maychill, watching from Gladstone. Maychill, my brother-in-law lives in Gladstone. I've spent a lot of time in Gladstone over the years. Haven't been there for a while, but I know Gladstone quite well. Brenda. Hi man, my partner had an open AET case and yet to finalize. I've read your waiving Schedule 3 criteria blog. So again, just to be clear, anyone who is applying for an onshore partner visa that doesn't have a substantive visa, so if they're on a bridging visa or if they're unlawful, so typically people will find themselves in that scenario if they've had a visa cancelled before and they don't appeal, or they appeal and they lose and they stay beyond that process, they then become unlawful at some point, very common. Or if someone's applied for a previous application, let's say trying to extend their student visa, or they've had issues with an employer-sponsored visa, they've appealed, and they're on bridging visas waiting for those visa outcomes, then they look to apply for a partner visa with their Australian partner. That's where Schedule 3 fits in. And that's where, I suppose that's where Brenda finds herself, or her and her partner find themselves at the moment. He's on a bridging visa for more than 28 days due to AT case. That means he's not satisfied. Can we apply for a partner visa? Yes, so Brenda, the way I suppose Schedule 3 is worded is that if you're on a bridging visa for more than 28 days and you're trying to apply for a partner visa, you fail Schedule 3. So you do not satisfy Schedule 3. So what that means is you need a Schedule 3 waiver. So that's when we talk about Schedule 3, what we're actually saying is that you need a waiver of Regulation 3001. So most people will be on bridging visas for more than 28 days. Therefore, if they go to apply for a partner visa, they will fail that requirement. So you need a waiver. And the only way you can get a waiver is to show compelling and compassionate circumstances. And as you probably read in the blog, Brenda, there isn't any legal definition of what that means. It's not defined in the regulations or the act, which is the law. All we can really go off is what government policy says. So government policy is the guidebook, what helps case officers interpret the law when it's vague, such as in this scenario or in this context with this criteria. We can look at decisions that were refused and then went to the tribunal to see which tribunal cases won or were given Schedule 3 waivers or which were not, and try to see if we can determine what facts tend to lead to successful cases versus which facts do not lead to successful cases if there's Schedule 3 issues. And I suppose statistically, based on our research, the cases that have the higher chance of approval or getting a waiver is if there is a child of the relationship, a biological Australian child of the relationship. However, that is not always a guarantee. It doesn't work that way. It's completely subjective and discretionary. The tribunal, the department will factor everything in. They'll look at the immigration history of the applicant. Are they using this partner visa as a way of kind of circumventing Australian visa requirements? They don't want to make it easy for people, particularly those that have been unlawful for long periods, just because now they're in a relationship with an Australian, and just because now they have a child or children. They do make it difficult on purpose to disincentivize people from breaching visa conditions or doing the wrong thing, and then trying to fix their situation just by being in a relationship and having children. So that they don't want to incentivize people having children, I suppose, for the wrong reasons as well. So Brenda, unfortunately there isn't, to answer your question, yes, you can apply. Should you apply is a different question. Like I said, it's not easy to get Schedule 3 waivers. It's not impossible. I'm not saying that you won't get one. I suppose what I'm saying is that we as an agency do not take on Schedule 3 cases unless there's a child. Because like I said, we know when there's children, we have something we can argue, because it's in the best interest of the child who's an Australian, who has nothing to do with any of this. It's not their fault that their parents find themselves in this scenario, and we kind of argue it from the child's perspective, not so much about the applicant or the sponsor. Nicole, I've heard from other migration agents posting in those groups, Partners Apart, saying that it is a huge risk to declare intention of applying for either visitor visa or travel exemption, and if a visitor visa is declined, that you will be affected in applying for visas in the future. What are your thoughts? Nicole, I would respectfully disagree with my learned colleagues. Visitor visa criteria is subjective. It's a lottery, which I know you've personally experienced, and I know your scenario specifically, Nicole, and that you're still waiting, I believe, for your outcome. Those agents perhaps haven't read the government policy that specifically covers applying for visitor visas in scenarios where there is a declared relationship with an Australian and an intention to apply for a partner visa. I can tell you from experience that we've had visitor visas approved to people that have declared an intention to apply for a partner visa. I can even tell you that in one particular case, we had submitted the initial visitor visa application using the old method of not declaring and trying to suppose, not conceal, but just not openly declare that they're in a relationship for the purposes of a partner visa. and we just provided the traditional documentation to say that they're going to go back home. Return flight, family back home, property back home, employment, etc. First visitor visa was refused. Then we looked into it further, we looked at the policy, and we told the client, look, there is this policy option. We haven't tested this before. It's quite new. We haven't seen this in the policy before. We're not told when policy updates, unless you're kind of reading it regularly, you don't know. And we said, look, it's worth a try. It's worth a try. Because if it doesn't work, the alternative is always to apply for an offshore partner visa, which I may answer your second half of your question, Nicole. And the client agreed that it was worth a try. We applied, we changed all the documentation. Same facts, same couple. We declared the intention. We addressed the concern about overstaying or becoming unlawful because we said they were going to apply onshore. We addressed the concern about them working in breach of their visitor visa conditions because we provided financial supporting documentation from the Australian sponsor. And it was approved. And the applicant has come on shore, and we have since applied for a partner visa. So I can tell you from experience that we've had it successfully approved, and we've done it one other time as well. So I know that it works. The other agents probably haven't tried, or they don't know that they can try. So I can't answer, I suppose, why they're saying those things. I understand probably why, because it is to some degree a risk, but everything's a risk. Applying for a visitor visa and not declaring and trying to get a visitor visa approved, trying to say you're a tourist during COVID pandemic period is probably more of a risk. I mean, kind of think of it, approach it logically. You're going to have risks. To me, in my opinion, declaring the intention to apply for an onshore partner visa is a lot more consistent. You're laying the foundation to give the case officer every opportunity to give a favorable decision because you're being transparent, you're being honest, you're addressing their concerns about visa breaching and staying unlawfully, and it sets up the eventual partner visa application because you've declared it initially. So even if the visitor visa is refused, if you then revert to plan B, which is an offshore partner visa, you can use that. You can use that as part of your evidence for the partner visa. You can say, hey, we tried a visitor visa to be together. That's how committed we are to the relationship. We tried and we declared the relationship. We provided all this supporting documentation to you guys, and you still refuse it because of various reasons, but at least we were honest. So now we're applying for the partner visa because that's all we have left. Versus applying for a visitor visa, not declaring it, it being refused, and then reverting to a partner visa that isn't as consistent. So to me, the pros outweigh the cons, but I can't comment as to why certain agents are saying certain things. If a visitor visa or travel exemption is refused, that has nothing to do with the future partner visa application. There is nothing in the law, in the partner visa criteria. Nicole, if you've attended the Partner Visa Secrets live training, the law that we go over is the law. That is what is required. Aside from, I suppose, things like health and character, which we don't go into during the training, that really is all that needs to be satisfied. There is nothing in the law that says if you've had a visitor visa refused from offshore or a travel exemption refused from offshore, that's going to have an implication to your partner visa. It doesn't say that. And they're two separate applications. Travel exemptions are not assessed by the Department of Home Affairs, they're assessed by a different arm of the government. So in no way should being refused visitor visas, particularly if you declare the relationship, or travel exemptions have any implication to a future partner visa application, okay? Should have no bearing because it's not covered in the law. There's no grounds for a case officer to refuse a partner visa because of a previously refused visitor visa or travel exemption application. Those are my thoughts.